Good afternoon, it's Mark Gracie here. I'll be running you through the webinar. Thanks for joining. We're going to be talking about the General Data Protection Regulation and specifically covering some topics off relating to how the GDPR impacts on cloud-based services and software as a service. Hopefully you can see the screen and you can hear me talking. You should see on the screen a big blue box with the title of the webinar in the middle. I'll be skipping through a few slides as I talk. If you've got any questions, we'll pick those up at the end. In your control panel, there should be a question box which you can add to type a question, and as I say, I'll pick those up at the end. Okay, so just to introduce myself, as I said, my name is Mark Gracie. I run a digital consultancy called Flavorify. And I help businesses look at what they do online, including general data protection compliance, privacy compliance, and data security. And I run a service called the Digital Compliance Hub. I'll talk a bit more about that a bit later on. My background is actually in internet and telecoms. I've worked for internet businesses since the mid-90s, and an element of one of my roles was being a data protection officer, so I know all about data protection under the Data Protection Act and how that impacts on businesses, particularly when they're processing large quantities of data. The bulk of my career up until 2014 was in an internet regulation and regulatory compliance role, working within the business to ensure compliance, including with data protection and data retention, but also influencing external stakeholders like the government and regulators, and working across the internet industry to ensure a good regulatory environment for the businesses I've been working for. But as I say, now I run my own consultancy called Flavorify, and today we're going to talk about the General Data Protection Regulation. I suspect everyone on the call's probably heard of that. There's a lot of noise about it going on at the moment. Everybody seems to be talking about it, as it's very topical. There's just over 9 months until it becomes UK law. But what we're going to cover is I'll just cover about the GDPR in an overview sense, so you get a good picture of what the GDPR is changing with regards to data protection rules in the UK, and specifically what that means for cloud services and cloud providers. And hopefully by the end you'll have a good idea about all of that, and we'll be able to start thinking about whether that's something you need to worry about and how that factors into maybe your service or your business, and hopefully some thoughts and sort of practical steps that you might want to consider if you're realise that you do need to worry about it, and what you need to do to comply. So first of all, just by way of introduction, let's talk about data protection. What do we mean by data protection? Well, in the UK we have the Data Protection Act that was implemented in 1998 based on a European directive. And it's all about processing of personal data. So that's data relating to living individuals. Certain types of corporate data or business data is considered as personal data. And if you get into the realms of marketing and processing data for marketing, even business data, there's rules specific to what you can and can't do with electronic marketing to business data. But data protection, and what we'll be talking about and focusing on is the processing of data relating to living individuals, or personal data as it's referred to in the legislation. And that relates to a data subject. So you end up with essentially three core groups of people in data protection legislation. You have data subjects, which are the people whose data it is that you're maybe processing or storing. You have data controllers, who are the people who are collecting, processing, storing that data, and you have data processors, who may be the data controller, but in some instances may be an external third party who process the data on behalf of the controller. And in terms of the GDPR, and what we'll be talking about actually, being a data processor is something that's very key to some of the changes that are coming. So when I talk about processing of personal data, what I'm talking about is essentially 8 data protection principles which exist in the Act and also in the General Data Protection Regulation around the fairness of processing, the purposes for having that data, the fact that it is kept up to date, what you're allowed to do with it, how you're allowed to process it, what the data subjects expect from the use of that data, and the rights that those data subjects have in terms of asking you things about what you do with their data and how you use it and how you process it, as well as other rights around asking you to stop using it and deleting it and keeping it up to date, as well as sort of the typical things around security. And certainly when we start talking about cloud, something that's worth always thinking about is international transfer of data and how you handle data when it is stored or processed outside of the EU, bearing in mind that this is very much a European set of regulations, the Data Protection Act and the GDPR that will be replacing it. So that's personal data, and when I talk about personal data, as I say, I'm talking about personal data relating to living individuals rather than corporate entities. When it comes to the General Data Protection Regulation, this is a new European regulation, regulation being the key part of that, in that it applies across the whole of Europe. The previous rules were bound around the Data Protection Directive. A directive allows member states to implement the law within their own laws in very specific ways, but there's often an opportunity to interpret that how you want. And what they've tried to achieve with the General Data Protection Regulation being a regulation is actually to streamline the interpretation of data protection law across the whole of Europe. So this is a European regulation that applies to all member states of Europe. And if you come across anybody who says, but we're leaving Europe, surely we don't need to worry about it. Well, unfortunately, we do. This is coming into play next year on the 25th of May 2018. And if things all go well for the government, we won't be leaving Brexit until 2019. Although I think I saw something the other day that said that that might even be later than that. So if anything, this rule is going to apply to the UK from next year for at least a year until we leave Europe. But actually, in actual fact, when we leave Europe, our laws as they are at the point of Brexit will still be the same the day after we've Brexited. And so GDPR is very relevant, and it's also very relevant in other areas as well when you consider how you deal with data stored outside of the EU, of which we will eventually be a third country, is a term that's used in the regulation relating to processing of data outside of the EU when it's EU citizens' data. So this fan diagram is essentially giving you sort of a very bullet point summary of the main changes that are coming. I'll just quickly whisk through those. They're obviously much more complex. We are talking about law, and law is complex. So I'm possibly oversimplifying it, but just by review, these are the main areas that are changing. Scope, the most significant scope change is the fact that data processors are now within the regulation and have specific duties covered in the regulation, where under the directive they didn't. And the scope also covers, as I said, this regulation covers the whole of Europe and applies to all European member states. Definitional wise, there's not much of a change, although online identifiers, things like online channel handles and IP addresses, it's clarified are personal data, so they are now within scope if you ever had any doubt that they were before. Children is on there because there's specific rules around how you process data relating to children, specifically when you're seeking consent from a child for the use of a service. So if you run a service that a child's likely to use, then you need to make sure that your messaging is clear and understood by a child, so which isn't a bad thing generally. I think if you can write stuff that a child can understand, then it's probably good for most adults as well. But you need to get parental consent or guardian consent for the use of the data for the purposes of which you're collecting it. So that's a specific step change in terms of a real carve out in the regulation about the children's data in particular. Consent, this is certainly a big one, particularly if you're involved in marketing. Consent relates to asking permission to use data for specific purposes, and the regulation is really changing in that you have to have an affirmative, positive consent. So somebody has to actually purposely say they are consenting, and they need to clearly understand what it is that they're consenting to. So the description of who you are, what you're going to do with the data, why you need it, and everything needs to be clear and transparent. In a marketing world, what this means is that the typical pre-ticked box saying untick this box if you don't want to be marketed to will be going, because that will be unlawful under the regulation, and you'll need to have a very clear message with a very obvious tick here if you want, if you consent to us marketing to you, kind of messaging. So consent's certainly a big one. As I say, if you're involved in marketing, or you're working in a business where you do a lot of marketing to consumers, you want to make sure that you're on top of the changes, because that's going to change the way you collect data, be it in your paper forms for marketing purposes, or collecting data online. Individual rights, I mentioned that earlier. There's a number of rights that allow data subjects to get access to. There's a number of rights for data subjects. One of them is the typical one that most people know about, is the data subject access request, which is the ability to ask a data controller what data they hold on you and how they process it. The regulation introduces two new individuals' rights. One is about data portability, so that's being able to provide data in a way that can be easily exported and imported into another system. Whilst most people will think that that's so that they can move to a competitor, there's also, it's not necessarily what that's about. It might be that they want to process the data in their own little database or in their Excel spreadsheet, but the regulation specifically requires the ability to allow a data subject to get access to their data in a standardized format. And something that might be an issue for some cloud services, and certainly software as a service type systems, you'll need to have a think about how you can provide that functionality in a way that A, is secure, but also enables that portability right. And the other additional right is the right to be forgotten. So that's ability for an individual to say that you have no reason to have their data anymore, and that you want to make sure that you delete all copies of it across their systems. This clearly isn't a right that says delete all my billing data so that you can't bill me, because you have a right as a business to have access to data that you need for the purposes of delivering on a contract. But it does mean that if you have data that you might have within your systems, and you might have to think about how you're going to anonymize that if it's no longer relevant to the service that you're providing. There's some new rules around certain types of processes of data, and around documenting those processes and how you process. There's data protection by design and privacy impact assessments. This is basically making sure that if your system is handling personal data, or you have a service or some kind of process that is introduced, you need to consider how data protection and the data subject's privacy will be impacted by the use of that system. So if you're coming up with a new product or service, you need to have somebody involved in how data protection is considered as part of the implications of using that service. And privacy impact assessments is a way of achieving compliance and making sure that your service is indeed compliant with the GDPR. And in fact, those last two, documentation of processes under certain circumstances and privacy by design or privacy impact assessments. The privacy impact assessments right now, but GDPR refers to the data protection impact assessments, to make that clear. Those are a couple of things that are worth bearing in mind when you're looking at cloud-based services. Some types of businesses need to have a data protection officer. That's what a DPO is. That's over on the yellow arm of the fan over on the right-hand side. These are people within a business who have responsibility for data protection compliance, and there are certain rules that certain types of organisations need to have one by law, and they're allowed to get on and do their job without being hindered by red tape or people within businesses trying to hold them back from doing their job. So there's some strict rules around what a data protection officer should be expected to do. Not everyone's going to need a data protection officer. In fact, most businesses probably won't need one. But if you are a business that processes a lot of data, or data that could be particularly harmful if it was misused or had unlawful access to it, then there's a good chance you probably need to at least be thinking about having a data protection officer, even if it's not one that you've lawfully required to have. And then the last two strands there, breaches and fines. Breaches for some regulated industries, telecoms for example, breach notifications is something that has existed for some years, but the GDPR introduces the concept that if you process data, under certain circumstances, if a data breach occurs, then you may need to report it to the regulator, who for the UK at the moment is the ICO, the Information Commissioner's Office, and you may need to tell the data subjects as well, so that they can make sure that they can protect themselves, if particularly if the data is something that would be harmful to them if it was out in the public. Credit card details is a good example of an area where you might find yourself having to report a data breach. And then the big stick that lots of people wave around is fines. Under the Data Protection Act, the Information Commissioner can fine up to about £500,000 right now, although it's all very proportionate. So I mean, you think TalkTalk from 2015 for their breach got fined 400k, and that was probably the largest fine. Most fines are under 100k. But the GDPR introduces two levels of fines. The top level is 4% of global turnover, or 20 million euros, whichever is the largest. And that's not to say you would be fined those kind of levels, but there's a potential that your fine could be significant, regardless of the size of your business. 4% of anybody's turnover is obviously quite significant within a business. So that was a very whistle-stop tour of GDPR. If you want to know a bit more about those in a bit more detail, I've got another webinar. If you go to Digital Compliance Hub's website and look at the events section, I've got another webinar that's specifically just about getting to know these main changes. So you might want to look at signing up for that. So where does this fit with cloud-based services and software as a service? Well, because of the role of processors, which we'll just talk about first, there's actually quite a significant change. So under the Data Protection Act, the role of a processor, so remember, a data processor is somebody who is processing data. That might be the data controller, but in some circumstances it may be that the data is being passed contractually to a third party to process the data on behalf of the controller. Under the Data Protection Act, a data processor has a contractual relationship with the controller that basically makes sure that they behave and don't misuse the data, and that they have security protocols in place, those kind of things. But all the responsibility for the compliance lays with the controller. So if there's a breach and the data processor did something wrong, it would be the controller that would get themselves into trouble, and they would have to prove to the regulator, the Information Commissioner, that they have taken all due diligence and taken their responsibilities seriously, and that this was the processor's problem, not they had no reason why they would expect the processor would have got it wrong. But all responsibility lies with the controller, so there's no regulatory control over the data processor. However, that's all changing. Under the GDPR, there are specific references in the regulations about data processors. In fact, if you go through the GDPR, you'll see it talks about requirements of a data controller or a data processor quite a lot. So the data controller will need to carry out proper due diligence and make sure that the processor they're going to use is capable of upholding the rights or their rights as a data controller. There's much wider and very prescriptive rules around what contractually the controller needs to make sure the processor addresses, and that covers a whole range of things, from security right through to only being able to process the data on written request by the controller. Certain types of processing of data will need to be recorded so that the information commissioner, if required, can ask the processor to provide documented evidence of how they process the data on behalf of the controller. If there is a breach, the processor has a legal requirement to tell the controller that there's been a breach, and they have joint responsibility along with the controller, as well as in some circumstances their own liability as a processor for any non-compliance. So as the text on this box indicate, certainly the switch over to GDPR is waking a lot of data processors up to the fact that they've got a lot more responsibility than they've had up until now. So that's the sort of precursor to where that factors into cloud-based services. And the answer to, well, what does this mean for cloud-based services? Well, actually, if you're providing a service where your customers are putting personal data into your service and you're hosting that in the cloud, then you are suddenly a data processor. So your customer is a data controller, your cloud service is as a data processor. Obviously, if you provide software and it sits on a server or on a terminal in your client's network, then they are still the controller, and they are still the processor of the data, because you're just providing a tool to enable them to do the processing. But if you're running a service where you are providing the service online and your clients are putting data into that service, then I'm afraid you suddenly become a data processor, which is why we're talking about what GDPR means for SaaS and cloud. So the main things to consider, and probably, I mean, if you're already doing these things, you're probably already starting to be asked this by your clients, but you are likely to be asked for more information from a due diligence point of view by your customers as to how your system allows them to comply with the regulations as to relating to their role as a data controller. So you will need to provide a compliant service that is not only compliant from the fact that you're processing the data, but also compliant from the fact that it allows your customer, the controller, to be able to stick to the rules relating to how they process the data. So you can expect not only contracts or watertight contracts in terms of those very specific things that I mentioned before around confidentiality of data, security, making sure that the data processor enables the data controller to meet their obligation, and able to demonstrate compliance, are just an element of a due diligence check by your customer or your users. You'll need to make sure your system complies, therefore, with the 8 data protection principles, including the functionalities that enable the data subject to get their data exported, and the other principles around security. I mean, security is clearly the one of the key areas, but there's also some questions about, well, actually, how does it work relating to data storage and where you're storing your data? Depending on how your cloud-based service is operating, you need to now think about, well, actually, because of the way that we store the data, even though we're providing the service in the UK, if the data servers are stored somewhere else in the world, then you need to be clear that that is what's going on, and you should be being asked by your customers or users for clarity about where you're storing their data. And you will need to make sure you've got all of the relevant checks in place to ensure that where you're storing it, if you're using third parties as well, that A, your customers are happy that you're using a third party, and B, that they understand that you're storing that data in another state, be it outside of the EU. And of course, when Brexit comes, that introduces an interesting point with regards to where we sit as a third country and being outside the EU, regarding any EU customers you might have, and the storage of our data, so of their data. So you're likely to have to start thinking about things around the place in which you're storing that data and whether it is secure and meets the principles of data protection. You also need to make sure your service and system is fully compliant. So you'll need to start thinking about privacy impact assessments, and you might need to work with your clients about how you can prove that you've considered all the privacy rules and regulations, and how they are impacted by the use of your service. And depending on the kind of data you're processing, there's a good chance you need to have documented processes so that you're clear. And that's not a bad thing to have anyway, whether you're regulatory required to have those processes documented. It really is a good idea to have everything relating to data protection documented in policies and procedures, and making sure that your business adheres to those policies and procedures, simply because you can demonstrate that you've actually thought about this and made sure that your service is as compliant as you believe it should be or needs to be. And in some circumstances, if you get that wrong, the Information Commissioner, if they're investigating you, would probably err on the side of telling you off rather than just jumping straight into a fine or carrying out an audit. But there's obviously no guarantee of that. But if you can demonstrate that you've taken great care and consideration of data protection, you'll be in a better shape than if you don't do anything and try and ignore it. There's also some things just to be careful around data ownership. I'm sure we've all heard these horror stories of your data isn't your data because you store it on a cloud-based service, and the cloud-based service claims ownership of your data. Typically, we're talking about the big social media networks you tend to get that kind of story with those, but I think it's relevant for any cloud-based service. You need to be clear that you as a processor can't claim any ownership of the data, because it isn't your data. Your service is only providing the processing functionality for the controller. And I've already mentioned actually the data transfer storage part of where things might sit. So if your data is shared across through mirroring, server mirroring, or any other kind of storage functionality that helps optimize your service, you'll need to consider exactly where in the world they might be, what their rules are relating to data, and you might have to carry out your own due diligence against your hosting provider if it's not your own hosting, and so on. So, but I think it's sort of very a complex piece of law, but in essence, the summary is, as a cloud-based provider of a service that is processing personal data, you will be considered as a data processor under the General Data Protection Regulation, which means that you have certain responsibilities. It also means that, and this is one of those responsibilities, is that you will need to answer to your customers and prove to them that your service is compliant with the data protection in a way that enables them to be compliant with the regulation. And that's why we're starting to see these GDPR notifications, particularly from cloud storage services in the US, where they're setting out their GDPR compliance. It's an effort to try and sort of appease everybody and say, actually, these are the things that we do because we know that you need to be compliant as a user. So those are the things that you need to start thinking about, and you need to make sure your service facilitates your customers from being compliant. So not only do you need to think about how your service can be compliant, you need to possibly deal with the prospect that you're going to get people asking you, how does your service enable them to be compliant? Because controllers will have a duty to ensure that they've carried out due diligence on the services they're using. So I hope that was useful and sort of gives you some food for thought. As I said, there are certain articles, 28 and 29, and around that area in the GDPR, which it's worth having a read and having a look at, and the relevant recitals within the regulation, because they really are specific about processors and processors' duty. And I'm afraid if you're running a cloud service that's processing personal data, you are a data processor for that purpose. So if you're listening to this and thinking, well, actually, what does this mean in terms of what I need to do? Well, there's sort of as I see it, a 5-step process, which is actually no different than if you're carrying out a GDPR audit on your own data and trying to work out whether you're compliant, regardless of what kind of business you are. You essentially need to prepare, audit, analyze, deliver, and then manage ongoing compliance. The preparation stage, that will depend on where you're at in your business, but you need to understand your GDPR obligations. You need to make sure your business are fully signed up to the fact that somebody needs to do something about it, and you need to form probably an internal working group to look at how you're going to deliver that compliance. You then need to carry out your audit, and that's looking at your system, your software, your services, where you're storing your data, how you're processing it, what the expectations are of the of your customers, the controllers, and associated documentation and policies, so that you can build a picture of the things you need to be looking at. So you have some kind of register, perhaps, of so in a GDPR audit sense, we'd be talking about data, systems, and policies, and you'd have a register for those so that you can identify the areas that need to be addressed. And that's essentially what I'm suggesting here as well. You need to understand what you've got right now, and then you can move on to the analyze section, which is actually look at all of that, be it your client's expectations, the data that you're processing on their behalf, your platform and how your system works, as well as your internal processes and the processes for your platform, about forming a plan of action on how you bring that up to being compliant or delivering the compliance for your clients. And then that brings you to the fourth stage, which is your delivery. So that's carrying out the work that is necessary to meet your compliance, and dealing with your clients if they're asking you for the proof that your service is compliant or enables them to be compliant within the rules of the GDPR. And then the final step, for a lot of businesses, data protection seems to be a tick box exercise. We've done it, we don't need to worry about it anymore. But actually, there is a need to keep on top of everything from a management point of view. So this data protection has never been a box ticking exercise. It's about managing your ongoing compliance. The rules may change. We've got Brexit to think about. We've got the fact that this is European-wide regulation, which might change depending on how member states interpret certain elements of the rules and regulations. We've got guidance coming from the Information Commissioner. We've got guidance coming from the Europeans' Article 29 Working Party, which is the collection of regulators across member states. There's a whole host of reasons to just keep up to date with what's going on. You need to make sure staff are regularly trained so that they understand the duties and obligations. You need to possibly carry out ongoing privacy impact assessments and how they might, or data protection impact assessments and how your service enables your clients to remain compliant. You may need to provide functionality that your clients are demanding around some of their duties for things like portability and right to be forgotten. So don't think of data protection as whether it's data protection actual thinking about or the GDPR as a box ticking exercise. It's an ongoing managed function of the service that you're delivering. So as I say, five steps to think about: prepare, audit, analyze, deliver, and manage. Which brings me really round for you to be thinking, well, where does 2018 take us, and where do we need to go beyond that? As I said, we've got the GDPR becomes a new UK law in 25th of May next year. And I've already talked about, what the impact of Brexit might have, case law, what the Information Commissioner might be doing with regards to investigations that they might be carrying out. And in the UK, we've got a data protection bill, which will implement certain derogations from the GDPR and some other data-related directives. It's worth paying attention to that as well, in case there's some things that might impact on the way that you might be processing data. And the e-privacy hexagon there is just a nod to the e-privacy regulation, which is coming sometime next year. They want to roll it out at the same time as GDPR, and this is the regulation that sets out things like cookie control, but also how you use electronic marketing. So if that's something that's relevant to your business, then it's worth paying attention to that as well. So over the next couple of years, actually, I see data protection and data privacy, and certainly if you're in marketing, this is a big thing. Is going to be a lot of activity going over the next couple of years, and Brexit is probably only set to complicate and make things slightly harder for us when we actually leave the EU. All things which need to be borne in mind when you're thinking about your role as a data processor. So that sort of takes me, I guess, onto a quick sales pitch about how I can help. I provide a number of services as my consultancy, from compliance audits through to management and training, and ad hoc consultancy. So if you're listening to this and thinking I need some help with how I'm going to make sure that my service is compliant, then you know, we can talk about compliance audits, or we can talk about consultancy. If you think you need somebody in your business on a regular basis, then we can talk about data protection management and how that works. And in fact, I'm already talking to a number of software vendors, or have spoken to some software vendors, about how their software and how their cloud-based services are impacted by the GDPR. So please do bear that in mind and get in touch if you want to discuss that further. And then underlying all of that is the other service I run, which is called the Digital Compliance Hub. This is an online service which gives you access to well, it's sort of two sides to it, really. There's the informational side, so it's guidance, advice, toolkits to help guide you through what you might need to consider relating to the GDPR, but it also looks at privacy and marketing regulation, web and data security, and includes workshops and things like that. But the other side of it, so there's the informational side and the guidance side, is actually the support, and it's a great way of having a sort of regular knowledge that you've got somebody to help you if you get stuck, or you've got a question. So if you're looking for a cheap service to have somebody on tap when you need them, then Digital Compliance Hub might be something you want to have a look at, because an element of that is having access to email support and being able to book telephone sessions so that we can talk through some of the issues that might be affecting you, or help you answer some of the questions you might have. And if you sign up now, there's currently a free month's trial, so you can try it for a month, and obviously let me know how you feel if you do that. So that's a couple of ways in which I can help you. I hope that's been useful. We got probably about 15 minutes left, so if you want to ask some questions, then now's probably a good time to do it. You should see in your control panel a question section. You can just type your question in there, and then I'll pick it up. So I'll just give you a few minutes there to have a think about that. In the meantime, I'd have had some questions emailed to me in advance, which was great. One of the questions, thank you, Elena, was if you just have email, phone numbers, and IP addresses rather than a person's name, is this still considered personal data? Well, I'm afraid personal data, it does include email addresses, phone numbers, and IP addresses. So depending on the kind of processing and the kind of data you have, there's a good chance that it is still personal data, and therefore is covered by the General Data Protection Regulation. Another question was something I touched on, in fact, was if you're storing personal data within a cloud system and it's being processed outside the EU, if it's not directly downloaded onto somebody's PC, is it still considered to be compliant? Well, I'm afraid it's not about being able to access and store the data on local devices. It's actually about accessing that data outside the EU. So if you're using third parties, e.g., you might be using a support center in Asia somewhere, then you need to make sure you have watertight contracts with those third parties to ensure that they stick to the rules of European data protection, and there are specific parts of the General Data Protection Regulation, as there is under data protection right now, about how you engage with third countries, so countries outside the EU, with regards to data transfer. So that would still be relevant. I'm afraid it's nothing to do with whether they download the data or not. And another question. Can I please clarify if corporate emails and phones are personal data? So, as I said, a lot of data protection is about personal data relating to living individuals. So often B2B businesses tend to ignore data protection on the basis that they're dealing with corporates, and actually that's not strictly true. There are certain types of business data that is considered personal data. A good example of that is a sole trader as a business, and that would be their data would be considered personal data, and therefore has to be treated in the same way as though it's a living individual's data, even though it's relating to their business. And indeed, a contact, say an email or a phone number relating to an individual within a business, that too is personal data. But where the things change is when you consider how you might be using that data for the purposes of marketing, and that's where the privacy and electronic communication regulations or the new e-privacy regulation comes into effect, because that dictates how you can manage that data for the purposes of marketing. And basically what it says from a marketing point of view is, if you have a person's email address within a business, you can only market to them if it's relevant to their role within that business, but it is personal data nonetheless, and you have to provide an opt-out. If you have generic data, so things like info at or accounts at, that kind of thing, or hello at is a lot of businesses use, then that's generic business data, which isn't personal data, and you can market to those as much as you like, provided you provide an opt-out. So I hope that clarifies that essentially there are bits of business data which is considered personal, particularly if it relates to sole traders and certain types of partnership. And if you have the if you have the email or data relating to an employee, that is personal data, and therefore needs to be processed with data protection in mind. Where it gets a bit fuzzy is when you start talking about marketing, but that's all about privacy. Okay, I'm just waiting for a few more questions. Coming through. Spare me a second. Okay, Elena's busy typing, so please, yeah, carry on. I'll pick up on your question in a second. Everyone else, please feel free to ping a question if you have something there, and I'll try and pick that up. We've got a few more minutes before we'll close off the webinar. Okay, so Elena's asking some interesting stuff about telecoms regulation and how that relates to data, particularly relating to the recent revelations in Russia around them obliging telecom operators to basically record phone numbers and store records for 6 months. This is actually a very interesting subject, and is something that's been subject of interesting EU law for quite some time. In the UK, we've had laws that require the retention of communications data for law enforcement, for want of a better word, for quite some time, and certain telecoms operators, even in the UK, are required by law to store their records for a long period of time in case they're needed by law enforcement for the purposes of prevention or detection of crime. So in terms of if you have a regulatory requirement that is not in contradiction to the EU regulations, then you'll have to stick to whatever happens in those countries. So if you're operating in these countries that have data retention policies, then you'll need to stick to those. But the local laws won't be able to be lawful unless they comply with European rules. And there's some question actually with us leaving Europe in the UK, what that means for the kind of stuff that Theresa May was pushing for and continues to push for, and certainly has got some leverage with around data retention laws for the purposes of telecoms when we leave Brexit, because there'll be even less pressure on us as a nation to not have laws that completely match what our European cousins have in place. And so whilst the UK have some laws around data retention, and whilst the EU may have not necessarily supported those rules, certain derogations from certain bits of legislation, and in fact in the realm of data protection there are specific directives around law enforcement access to data protection which will be implemented in the UK in a particular way, possibly through the Data Protection Bill, which will enable us to have our own set of rules in that particular area. So if you're asking about data retention policy in countries where you're forced by the government to store that data, then that really comes down to the local law, which should in practice be compliant with the law of the land when it's as part of a group of countries. So Europe is a good example. If a European country is able to implement certain bits of legislation, as long as it sticks with the European rules, then they're usually okay. And as for whether it conflicts with the GDPR, well, that really comes down to how the laws are implemented and how the derogations, particularly around law enforcement access and the purposes for storage of that data, is implemented. And to be honest, if a member state wants to implement a piece of law which is even in breach of the European law, then it will then go through the European process of being challenged at high courts in Europe, and what will come of that is difficult to know. That's quite high level European legislative process that would need to be considered there. So I hope that answers everybody's questions, and I hope that session was useful. Obviously, if something comes to mind you wish you'd ask, then drop me an email, mark@digitalcompliance.co.uk, will find its way to me, and I'll endeavour to help. But also, as I say, bear in mind some of the services that I can offer that can probably help you meet your compliance, even if it's a one-off consultation to just go through what kind of service you're running and how the GDPR impacts on that. Do get in touch. Right, so no more questions coming through. So thank you very much for joining, and we'll leave it at that. Have a good day.